Yes, sir. Understanding of the NCERT. Now, just presently, perhaps there is a bit problem, some technical problem of voice. So I'm just trying to check it out. What the problem is there? Voice is presently. Perhaps there is a bit problem, some technical problem of voice. Okay, now it is clear. So, welcome again. And in this class, we are going to discuss the theory of separation of power. And we were discussing in the previous class that in relation with the theory of separation of powers, there have been several ideas given by several scholars. When we were discussing the historical background, we found that it was the idea of Aristotle that gained a kind of recognition with respect to the doctrine of separation of power or the separation of powers of the organs of the government. Thereafter, we also found that there have been some modern scholars like Bodin, Blackstone, and Montesquieu, who demanded separation of powers among all the three organs of the government. So, under this theory of separation of powers, हम लोग जरा देखते हैं कि क्या क्या चीजें हैं. So the first of all, why? Why separation of powers? The first question arises in my mind. Why separation of power? That has been answered by the NCERT book also. And I have discussed in the previous class that it is the liberty of the individual that necessitates the separation of parts. Why? Just because of the reason that if the parts are concentrated, in the hands of any individual like king or emperor or in any body, in any particular body, then that concentration of power may become the reason for the tyranny. As Montesquieu has said that concentration of powers tantamount to tyranny. Concentration of powers क्या करता है? टायरनी को बढ़ाता है, उत्पीड़न, अत्याचार का जन्म देता है. So in that sense, what we can do? So Montesquieu demanded we should have separation. And that is why separation of power. बात समझ में आई? So there should not be concentration of power because the concentration of power results in tyranny. उत्पीड़न, अत्याचार, atrocities. ठीक है? तो why separation of power? Just because of the reason to ensure liberty for the people or to ensure freedom. जो भी कह लें. Okay, चलिए. अब now, what is the meaning of separation of power? It becomes again an important topic to be discussed. Meaning. Actually, in this class, we will discuss the meaning of the separation of powers, thereafter its applicability, thereafter in practice, the situation in practice. Three things we'll discuss. ओके, तीन बातों का यहाँ पर डिस्कशन होगा. देन द थ्योरी ऑफ सेपरेशन ऑफ पावर विल कंप्लीट as it is discussed in the NCERT. So what is the meaning? The meaning, if you want to write, you can write also. The theory of separation of powers or the separation of powers means legislative, executive and judicial functions should be performed by different bodies and by different persons. So the meaning is functions should be performed by different bodies and persons. Just think over here. Different bodies and persons. What it means? It means that if there is the function of lawmaking, then there must be legislature. If there is the function of execution, then there must be a different body. And for judiciary or justice system, judicial functions, judiciary. So there are the bodies. There must be the bodies as well as the persons in those bodies should also be different. It should not be that the member who are the person who is in legislature or who are in legislature are the executives, and they are also the judges. It should not happen. So the difference or the separation is not among the bodies, but the persons who will be the members of that particular bodies should also different. पहली बात. Second thing, it also means that the powers of all the three bodies should also be separated. Powers should also be separated. Therefore, it can be said that every organ of the government, जानते समझते जाइएगा, every organ of the government should be limited to its own sphere of actions, own sphere of actions. First thing, it means, दूसरी बात क्या हो गई? No anybody can have controlling power over other. Okay? No anybody can have controlling power over other. Over other. Means judiciary cannot control legislature, executive, etc., etc., etc. Okay? This is complete separation, always remember. It means that the theory of separation of power advocates kind of complete separation among the powers of the organs of the government as well as functions of the organs of the government as well as and also in the persons who will be the members of that particular organ. Is it possible? So this doctrine of separation of power was adopted, especially advocated by Montesquieu. As I have told you, Montesquieu was adopted by US Constitution. But when we will discuss the US Constitution as it is discussed in the NCERT book itself, then we will found there that in the US Constitution also the complete or the separation of powers in its entirety is not there. Is not. So, what is in practice? Okay? What we find in practice. तो अब देखिए मीनिंग हो गया. So what is the real condition in practice? What is the real situation or condition? So लिखता है NCERT कि we do not find complete separation and it is neither desirable nor practicable. आगे जरा ध्यान से समझिएगा. If each body were completely independent in their sphere of activity, it could thought, the act of others. समझिए जरा. Just suppose it is executive body, it is judiciary, and this is legislature. So the NCERT is writing that if these could have been completely separate, okay, इनमें पूरी तरह से ये अपने स्फीयर में इंडिपेंडेंट हैं, वर्क स्फीयर में, फंक्शनिंग में, तो इट कुड थॉट, THWART, thought, the act of others. Why and how? Actually, what may happen or what will happen if all the three bodies will work completely in separation, then there might be the frequent deadlock between them. Frequent deadlock. Why frequent deadlock, dear friends? So the reason will be very simple. Legislature will make suppose legislature has made a particular law X, and executive may say that we needed X plus 1 law. You have formulated only X, so we will not do it. तो प्रॉब्लम हो जाएगी. इसीलिए एनसीईआरटी लिखती है कि क्या हो जाएगा, देयर माइट बी द unsuccessfulness of the actions of others. Okay, so what happens, इसीलिए एनसीईआरटी कह रहा है कि इसको बहुत जरूरी नहीं है, it is not needed that there should be complete separation among the functions and the parts of the organs of the government. Okay, further NCERT writes that actually the complete separation of parts is not practicable in its entirety. Okay? How? तो प्रूव करने जा रहा है अब एनसीईआरटी. तो एनसीईआरटी प्रूव करना शुरू करता है, तो कहता है कि इन प्रैक्टिस what we find. So in practice, just suppose legislative functions. So what is in practice? Actually, I'll discuss all the three: legislative, executive and judicial functions in practice. So what happens? In practice, legislature draws or formulates broader outline of a law. It draws a broader outline of a law, and for the detailing, it assigns the task to executive, and executive writes the rules, or you can say fills the rules under that particular act in detail, and the rules made by the executive body under that particular act which has been passed by the legislature is considered valid, same as the outline or the framework drawn or formulated by the legislature. There is no any difference. So what is here? It is very clear that there is the role of executives also in lawmaking. Similarly, executive has the power to promulgate ordinance. You might be knowing ordinance making power of the President of India, ordinance making power of the President of US, ordinance जारी करना, ordinance making power of the Crown of the Britain. So जो ordinance जो issue होता है, और ordinance are same as the law. Ordinance has the same binding authority as law. So executive is again playing a role in the formulation of law. So where there is complete separation, no complete separation. Similarly, judiciary also has some power to play a significant role in the law making. Okay, you know also that judiciary has the power to interpret the law, interpretation of law by judiciary, and when judiciary interprets a particular law, what it does, आपको पता है, and that power is called as power of judicial review. Okay, though it is not in Britain, but it is in India and US. And when judiciary reviews or interprets any particular law, it declares that particular law valid or invalid, as valid or invalid. And there is also one more thing, that sometimes judicial decisions get the authority same as a law. When judiciary, especially the apex court of a country, like in India, the Supreme Court, directs the government to do something or not to do something, then that becomes binding on all. For example, the model code of conduct related with the elections in India, जिसको चुनावी आचार संहिता कहते हैं, model code of conduct. Till now, the legislature of India have not passed any law. कोई act नहीं है वो. And when the election commission, after consultation with all parties, with all the political parties, formulated that model code of conduct, after some time there was a writ challenging the model code of conduct, how it can be enforced, because it does not enjoy the enforceability as a law, as it is not passed by the legislature, means the parliament. Then judiciary given the decision that it is valid, because election commission has such powers. अब क्या हुआ कि that is considered as a kind of judge-made law. So the judge-made law means all those things which has been given as are declared to be followed by the government and even by the people of the country by judiciary, then that is considered as the judge-made law. If, for that particular issue or matter, there is no any law existing. If the law is existing, then that can be interpreted, whether that is valid or not. ठीक है, तो ये बात हो गई कि क्या हुआ कि executive is playing the role in legislation, judiciary is also playing the role in legislation, and the ultimate objective of a law is what? Social good. As in the previous class, we have discussed that an organized society must have some law, and laws has to be implemented properly so that the social good can be ensured. ठीक है, अब जरा देखिए, judiciary in some cases performs some executive functions also, and all these things are written in your NCERT. Imagine, all these things are written in the NCERT. ठीक है, judiciary performs some executive functions also, like in USA, lower courts in USA is responsible for the maintenance of peace. Similarly, in England, justice of peace, the lower court called as or named as justice of peace is responsible for the maintenance of peace in the society, and maintenance of peace in the society is the responsibility of the executive. But in these countries, US and Britain or England, this is assigned to the judiciary also. Okay? And sometimes legislature also performs some judicial task. For example, in the previous class also we have discussed, for example, House of Lords in London or in England, UK, is the apex court or the supreme, has the supreme authority to hear the appeals. है ना? तो आप जरा समझिए कि वहां ये भी काम करता है. It means that, समझिएगा, it means that the doctrine of separation of power is not found in its entirety anywhere in the world. In India also, the executive body is formed out of the legislature, parliament. We'll discuss. उसका नंबर आएगा, सबका नंबर आएगा. तो अब हम लोग क्या करेंगे? The NCERT discusses British system, US system and Indian context. So, with respect to the theory or the doctrine of separation of power, NCERT discusses United Kingdom system, US and India. So, first of all, England. NCERT writes that English constitution, though there is unwritten constitution, always remember, English constitution maintains some kind of separation, only some kind of separation. Okay? Some kind of separation of powers. Some kind of separation of powers. आगे लिखता है एनसीईआरटी as the Parliament of Britain or United Kingdom is purely a legislative body and it is separated from the executive. But what happens? The members of the executive body are drawn from the parliament itself. So at the structural level, there is a relation, but in the formulation of law, there is separation. It is distinct from the executive. Similarly, the Act of Settlement of 1701, Act of Settlement, provided for the independence of judiciary from executive. Okay? Independence from executive. But again, as I was telling that legislature is purely law-making body, but the members of the executive are drawn from the legislature itself. So the cabinet system in UK is kind of rejection of the separation of power or the theory of separation of power. Similarly, the House of Lords is the ultimate court of appeal. So NCERT on these basis writes that in United Kingdom, the theory of separation of power is rejected. And if the question arises, if the theory of separation of power is rejected, then how to secure the liberty of individuals? बड़ा question है. If the separation of power is not there, then Montesquieu has said that the concentration of authority or the power, concentration of power tantamounts the tyranny. So, इस टायरनी से कैसे बचा जाए? How? What England did? तो जरा देखें. So, the question arises, if there is no separation of power, then according to Montesquieu, there will be the chances of the tyrant administration and governance. So, to be safe or to protect the liberty of the individuals, NCERT writes, the defense of liberty is sought to be secured through organized party system and pressure of public opinion. Organized party system and pressure of public opinion. Okay? जरा ध्यान दीजिए. If this is the statement given by your NCERT, then there are some inherent things. Inherent क्या है? कि if there is an organized party, political party system, then there will be and opposition means a party in power and another party in opposition. So the party which will be in opposition will raise the voices. If anything will go against the liberty of the citizens, then the English constitution framers, unwritten constitution है, फिर भी समझ लें, मान लें, the constitution framers or the English scholars and political leaders considered the political parties more important than the separation of power to protect and secure the individual liberty. क्यों? क्योंकि उनका ये मानना था कि अपोजिशन, उनका ये मानना है, they consider, they believe that the opposition will oppose any wrong done by the party in power for the protection of the individual liberty. Similarly, the pressure of public opinion, they consider that the people or the public of the country is well aware, and if anything will go against the interest of the public, they will create a pressure, they will create an environment of opposition and protest and all. So that has been left on this organized political party system and pressure of public opinion. Chaliye. So, for your preliminary examination, what is outcome? So, the United Kingdom or England rejected the theory of separation of power. UK ने क्या कर दिया? Rejected. Okay? UK rejected the theory of separation of power and relied on the institutional safeguards against the tyranny of government. This will be your answer. और tyranny क्या है? वही है, autocracy, absolutism, oppressiveness, है ना? चलिए. So now, after the English system, we are moving towards the US. USA. In USA, as I have told you in the beginning of the class, that the theory of separation of power given by Montesquieu was adopted. Why? Why it was rejected in Britain and why it was adopted in USA? Or you can raise this question in either manner. Why it was not considered very important to be accommodated and implemented and adopted by United Kingdom, and why US felt that it is very important to be adopted? Answer is in NCERT, but in a very inherent manner. कई लेयर्स में दबा है, उसको निकालना है, निकाल के बाहर समझना है. Actually, it is only due to the difference in the social and political conditions of both the countries. In Britain, the conditions, social and political conditions, were not complex. From the very, very longer period, there was a uniformity in social and political system. There was no any major hurdle for the liberal devolution of powers, while and one more thing, US was under the colonial rule, not the Britain. Okay, so these were the social and political complexities. So in USA, अब आ जाते हैं सीधे, in US the situation was different or the conditions were different, and due to that US ने जैसे ही कॉन्स्टिट्यूशन बनाया उसने इसको अकोमोडेट कर लिया. याद रखना ये वाला बात, कॉम्प्लेक्सिटी और कॉम्प्लेक्सिटी का ना होना. So in US there was complex social and political life, That is why the constitution framers in USA relied on the constitutional device of separation of powers. They adopted and accommodated the doctrine of separation of power, though in the Constitution of US also the theory of separation of power or the separation of power is not clearly mentioned, but is implied in first to third articles of the US Constitution, implied in the Constitution from first to third articles. And the Supreme Court or the apex court of USA has also recognized that separation of power is the part of the US Constitution. Okay? अब जरा देखिए how it is accommodated. In fact, how it is accommodated and how it is given or how it is accommodated in Indian Constitution, I think we need to discuss in another class, because that will take a longer time. And I have another class of public administration. That is why I would like to just make a request to you people right now that please tell to your friends, knowns and others about this course of NCERT and all subjects NCERT. Tell them that all subjects NCERT class is available in a very analytical and elaborated manner only in the fee of 6,250 presently, including the GST also, though later on it will become 12,500. So thank you for the day. Tomorrow we'll discuss further things or more about the separation of powers. Thank you for being with me.